learn how to be good stewards. We will listen attentively to see how to manage wealth in a Christian fashion for the benefit of those who need it most. As we enjoy our lunch, we will bless this food, saying, "Bless us, O Lord, and these thy gifts, which we are about to receive from thy bounty, through Christ our Lord. Amen." And we want to thank, of course, Kelly Wood from the Catholic Foundation of the Diocese of St. Augustine for joining us today. And, of course, our own Andy Decker, parishioner Andy Decker, who has many years of experience with wills and trusts and other forms of law. So I'll turn it over to you, Kelly.
Yes, sir.
Okay.
Thank you.
Thank you.
Good afternoon, everyone. I have to start by saying it's such a blessing to see all of us sitting here today. After those two hurricanes that we just went through, whether we had some property damage or not, we're here, we're alive, and we can enjoy each other's company. Like the deacon said, I'm Kelly Wood from the Catholic Foundation. And I'll talk to you a little bit after Mr. Decker has spoken. The Father has invited us here to the parish for a workshop that we entitled the Foundation Wills and Estates, to help you understand better what you need to do to be prepared to leave the greatest gift you can leave your family, and that is all of your business in order when you pass. We're very grateful that Andy Decker has agreed to give us of his time to speak with y'all today. Actually, he's a parishioner of y'all's that comes from Live Oak. He received his bachelor's at Duke University and then went on to the University of Florida School of Law to receive his Juris Doctor. And it's a pleasure at this time. And after Andy's finished, he'll have some time for questions at the end. And I will ask y'all, I'll pass out a survey at the end if you'll tell me what you thought about the workshop. That's how we make it better for all of you. And at this time, I'd like to bring Andy up. Andy?
What kind of questions do you want me to ask?
Thank you.
Thank you, Kelly, for that very kind introduction. I actually also had a year of graduate study at Georgetown in microbiology and viruses. At the time I was pre-med. Everyone in my family, my friends told me that I would make a lousy doctor because sick people got on my nerves, and so they also said I was an argumentative SOB, so maybe I should go to law school. So I went bound to going to law school. That's how it worked out. Before I begin, I want to provide you with a disclaimer of sorts. I'm not giving legal advice today. I'm trying to give you information and guidance on how you can work through your own estate planning. We'll be sharing with you a number of lawyers in our area. I think some of them are actually on the back of our bulletin every Sunday, but there's some excellent estate planning lawyers in our area. Because, of course, estate planning is personal and unique depending upon everyone's circumstance, it's not really possible for me to give legal advice, and I don't want anyone to rely on what I say as maybe being applicable to your particular situation. It might or it might not. Having said that, let's begin with a multiple choice question, just to have an understanding of where we are and what your thinking is. Here's a multiple choice question. How do you save a lawyer from drowning? A, throw him a life buoy. B, call the rescue squad. C, throw him a rope. D, all of the above. Or E, take your foot off his head. Which is it? All of the above. Christy's kind. A lot of people yell out E. So we don't want to do that. Why are we talking about estate planning? There's two basic things I would share with you initially. Years ago, there was a CPA in Madison County that I worked with on mutual clients for estate planning and tax issues. And he had someone come to him one day who began describing what he was anticipating and what he wanted to do by saying, well, Mr. If I die, here's what I want to have happen. And the CPA said, well, wait a minute. You know something I don't know? Because if you figure something out that the rest of us haven't been clued in on, well, I'd sure like to know what it is. because, of course, it's not if we die, but when we die. And the other thing we need to keep in mind is, and all the empirical information, all the empirical data supports this. Have you ever been to a cemetery and seen a Brinks truck or a U-Haul follow the hearse into the cemetery? No? No one has seen that. So we've established two things. We're all going to die, and you can't take it with you. And so what do we do with it? What's that?
Not even books.
Huh?
Not even books.
Not even books. Not even your favorite fountain pens. You can't take those with you. They stay here. So it's been established that we will pass away and we will leave an estate for those that survive us. Hebrews says, just as it appointed that human beings die once, and then after that the judgment. We will die. We will face the Lord. And we will leave an estate. That is sure and certain. The Bible has a lot of verses to tell us about how we should live our lives so that we actually have an estate and what we should do with it. Proverbs chapter 6 says, "Go to the ant, O sluggard, consider her ways and be wise. Without any chief, officer, or ruler, she prepares her bread in summer and gathers her food in harvest." Proverbs 10 says, he becometh poor that deals with a slack hand, but the hand of the diligent maketh rich. So the Bible is telling us, as a follow-up on what the Lord told Adam in the Garden of Eden, we're here to work. We're here to do our best, to be diligent, and to be good stewards. And everything in the Bible points us in that direction. One of my favorite verses is from Malachi, and this is something that we'll be touching on later today when Kelly begins part of her presentation. It's from Malachi, and the Lord is saying to the people of Israel at the time who were shortchanging him on their tithes and offerings to the temple, bring all your tithes into the storehouse and prove me, put me to the test, and I will show you, if you prove me and test me, I will open the windows of heaven and pour out a blessing, and there shall not be enough room to receive it. The Lord is saying that if we do our part as good Christians, as good stewards, and if we work hard to manage our lives, raise our families, and leave an estate, and we always remember the Lord in our tithes and offerings, that He will bless us more than we can ever understand. And when I was younger, raising two kids and car payments and mortgage payments and everything else, I thought that was impossible. But what I found out is I could not afford not to tithe, because the Lord, you cannot outgive the Lord, truly. If you give to the Lord, you give to your church, you give your time, your treasure, your work, whether it's on the grounds or whether it's in the church helping with things, the Lord will bless you and your family more than you can ever understand. So what should we consider in our estate planning? Who should we think about leaving our estate to? Psalm 127 says, "Children are a heritage from the Lord, the fruit of the womb a reward. A good man," Proverbs 13, "a good man leaveth an inheritance to his children's children, and the wealth of the sinner is laid up for the just." And then my favorite, I haven't heard this one in a long time, but the next time we have a stewardship campaign, we'll probably hear that. 2 Corinthians chapter 9. Anyone know that? You've probably heard it. I know you've heard it before. The Lord loves a cheerful giver. I've heard that. I've been to a lot of estate sales and bankruptcy auctions, and the auctioneer always starts with that. The Lord loves a cheerful giver. But truly, what this means is that we are given a lot of blessings in this life. As Father Sebastian told us in his homily today, we in this country have been blessed more than any of the people on this planet, more than any of the people who have ever walked on this planet. We have the health and the riches and the safety and the well-being that no one else on the planet can even fathom most days. We truly are blessed, and we're called upon to share those blessings with our family, provide for them in a way that is appropriate, and provide for our church, because as I said recently in promoting this talk, every week we take care of our families. Every week we take care of our church. The sacraments, the grounds, the things we do, the work that Father and Deacon and so many others do, it depends on our support. It depends upon our being there to help. And so all estate planning is an extension of that. When we pass away, can we do something to further that, to continue that ministry, if you will? And so that's what I'm going to talk about today. And I'm going to talk about estate planning in three parts, because estate planning does not just begin at the moment of death. To really, truly have effective estate planning, you have to be prepared for the phases of life prior to death, and then, of course, the time that follows our passing. And so, first of all, right now, everyone in this room seems like they're competent, healthy, hale, and managing your own affairs, right? But what happens if you become incapacitated? What happens if you get a stroke? Or your ability to communicate, your language skills are gone, or you cannot make decisions. What happens if you develop dementia? Which my kids, every day my daughter says, "Dad, Shady Pines." She thinks I'm one step away. But the first thing we need to look at is managing our estate, managing our property, our bank accounts, our investments now, before we die, if the time ever comes when we can't do it ourselves. And so most estate planning lawyers will talk to you about doing a durable power of attorney. A normal power of attorney ceases to be effective when you die or when you become incapacitated, or if you revoke it. A durable power of attorney continues to be effective even though you may become incapacitated and can no longer make decisions, you can no longer communicate on your own behalf. And this is very important, because if you're not able to handle property, business, financial, or checking matters, who is going to take care of that for you? Who's going to pay your bills? Who's going to see that the investments are renewed or perhaps reinvested in a different form? Who's going to help manage things and see that the taxes are paid, the insurance is renewed? Who will do those things? Because you can't do those things anymore because you're incapacitated. And so a durable power of attorney allows you to name someone to do that. It also allows you to have people on standby if the first or second person you've named can't do it. This is very, very effective and very, very critical for this reason. If you do not have a durable power of attorney, then any time a decision has to be made, somebody has to deal with your bank, with a title company, an investment company, or whatever. They don't have authority. The only way they can get authority is to apply to the court to be appointed a guardian. And then, a guardianship involves a 3-person examining committee, a doctor, nurse, social worker usually, and then they have to do a report. They have to interview the person. They have to file a report with the court. The court will appoint a lawyer for you so you have legal representation, usually someone in the community that will do it voluntarily for the court. And then there's a hearing to determine whether you have legal capacity. And then after that, there's a hearing to determine who will be the guardian. Now, sometimes family members all get together and decide that this particular person has the skill set to do it, and we're going to defer to that person. But oftentimes, there's a lot of conflict and controversy as to who's going to do that. That has to be resolved by the court. And you have a court hearing before a judge. Now, one of my golden rules I tell clients when I'm doing estate planning is the number one thing we want to do is we don't want to go to court. We do not want to go to court if we don't have to. And so if you have a durable power of attorney, you do not have to go to court because you've already set something up for someone to act on your behalf and be able to make these decisions. If you don't have that, then you have to go to court. When you go to court, it is an invasion of privacy, it's a lot of time, and guess what? A lot of money. Lawyers like guardianship cases. My rule is we don't go to court. We avoid that. We avoid probate. We try to avoid going to court. And so it is smart and a good stewardship to have a power of attorney set up. And usually people will pick as their agents the people they ultimately intend to select to be their executor for their last will and testament. But the first thing, of course, is a durable power of attorney, because that helps you to continue to manage effectively and wisely your property, your estate, and that your estate is what we're ultimately going to be talking about when we talk about estate planning. The second thing, following a durable power of attorney, and by the way, my wife will tell you that I rarely ever come up for air. So if you have questions, raise your hand, throw something at me. I'll be happy to answer any questions anytime. Yes, sir.
Just a quickie on the durable power of attorney, husband and wife team. If you have both names on the deed and on the accounts, the checking accounts, one wouldn't have the durable power of attorney the other, or you think that's still a safe bet?
Well, what I would do is, when I do durable powers of attorney for husbands and wives have reciprocal durable powers of attorney where they name each other, and then they usually have children on standby as second and third position, or possibly if their children are minors, they'll have responsible brothers or sisters in the picture.
Thank you.
Yeah. The second thing, any other questions? Okay.
A durable power of attorney, though, only will be in effect if you're alive. So make sure you reiterate that.
I said a durable power of attorney stays in effect so long as you're alive and you haven't revoked it. If you become incompetent and incapacitated, it's still effective. Thank you, my co-counsel.
As long as you're alive.
That's right. The next document is a durable health care power of attorney, and it goes by different names, either a living will, a health care designation, right to decline life prolonging technology. But this is also an essential part of preserving your estate and making wise decisions, because medical care in the last year of life is really significant. That's where the bulk of all the money is spent for Medicaid and for private health care insurance. And it's also something that is emotionally very, very helpful. How many in here remember the Terri Schiavo case? I think I see a lot of hands. Terri Schiavo was a young woman in her mid-20s, and she was married. The record in the court proceedings indicated that she and her husband were not necessarily getting along that well, and apparently she had told some girlfriends that she was thinking about filing for divorce. That was sort of the situation. She had some type of medical episode that left her, quote-unquote, brain dead. The term brain dead really is not a medically accepted term. It really doesn't tell you very much, but she had basically autonomic functions in the hind part of the brain, the part that does autopilot. That's the part now that's controlling your heart, your respiration, your blood pressure, your hormonal system, all the things we don't think about. It does all that automatically, including, for example, your ability to look at something and track it. If I was brain dead, which I already introduced myself as a lawyer, so you already know that. But if I had a situation like that where this part of my brain, the part I'm trying to use right now, if that part was gone, and somebody got up from this part of the room and walked to that part of the room, I would go like this and follow them. And you would think, well, Andy's in there somewhere. Don't pull the plug on him. He's in there somewhere because he followed that person. Not necessarily. You ever seen a flower in the morning follow the sun and turn, like a sunflower? Well, that part of the primitive brain that tracks motion, that has motion detection, which is very necessary if you want to find food in the jungle, also very necessary if you want to detect predators in the jungle, that part was still working for her, and she was still able to do that, but she had no other apparent function. And so, her husband said she would not want to stay alive in this condition. And of course, people thought maybe that was a little bit self-serving on his part. Her parents, loving their daughter, did not want to pull the plug. They wanted to give her every chance to try to see if there was any recovery, if the doctors could find some sort of treatment. Well, that case went through the entire United States court system, from the circuit court to the DCA, the District Court of Appeal, to the Florida Supreme Court. It went to the 11th Circuit Court of Appeals in Atlanta. It went to the U.S. Supreme Court. And I think it might have gone up and down several times, actually. And I think it was almost 7 years or so before it finally got resolved. And during that whole time, of course, she was in basically a vegetative state without any apparent function. And of course, the cost to the family in legal expenses and everything else was astronomical. You have the right under Florida law to decline you have the right to decline life-prolonging technology. You have a right to say, I want to be kept pain-free and comfortable, but I don't want to be hooked up to machinery and technology that if my death is imminent and my condition is irreversible, I don't want to be kept in that state. I want to be allowed to die with dignity, is the expression. And then there's a lot of other things you have the option to select. You can really custom make and fine-tune things however you want. Usually, a lot of people look at it from that point of view. Now, as Catholics, assuming most of us in this room are Catholics, Catholic principles of biomedical ethics also help guide us in decisions that are appropriate and decisions that are not appropriate. For example, a lot of people think, well, if you're brain dead, we're going to take away food and hydration. No food, no feeding tube. The church has traditionally viewed that as not an extraordinary measure to keep life going, but an ordinary measure. And so you can't deny someone food and water just because they're in a certain state. Now, I know that there's been recent articles that call the question whether the church may modify that, but for the time being, I think that's the way it is. But the basic principles of biomedical ethics for Catholics is that you have to first look whether the proposed act itself is good or at least neutral. You have to look at whether only the good is intended for that person. You can never use an evil means to a good end. You cannot do that. There has to be a grave reason for acting or for not acting. Sometimes there's a double effect in what we do or don't do. I'll give a classic example of a double effect. For example, a woman is pregnant. She has an ectopic pregnancy. The baby has been fertilized and developing in the fallopian tube. And so the doctors intend to operate to save the mother's life because that is a life-threatening situation. The double or secondary effect is the child will likely die. That was not intended, but that's a result. And so that is a permissible act from an ethical point of view. And every case is obviously very, very difficult to resolve. There's a lot of nuances. Having an informed and sensitive doctor and having the resources of a priest or deacon to help guide you are absolutely essential. But you have the right under Florida law to tailor-make how you want different situations handled, depending upon, your medical background, your family history, your own personal ethics, and your guidance, hopefully from the church. But those are all things that you have to consider. This is very important because when you're in that kind of stage, if you have not done a durable healthcare power of attorney ahead of time, then doctors and the hospital personnel have to decide who is going to guide them, who's going to help make decisions. If the wife is available or husband available, they would be looked to under the statute, which is Chapter 765 Florida statutes. It has sort of a standard boilerplate power of attorney for healthcare decisions, but it has a lot of other things that help you decide, help doctors and hospitals decide if the person can't speak for himself or herself, who do we look to in order of priority? And usually, it's what you would think. We look at spouses, we look at adult children, we look at parents, we look at brothers and sisters, and ultimately nieces and nephews. And so there's a logical progression for how it proceeds. But what if, you're in a situation where you're widowed or a widower, and you don't have any children, your parents have already passed away, and you've got a brother who is rotten to the core. Do you want him saying, "Yep, pull that cord like the rope on a cheap lawnmower, just you yank it, right now"? You can pick someone who knows you, who knows your philosophy, who knows your ethics, who knows your Catholic principles. And so it's important to name someone. If you don't name someone, then what happens quite often is somebody has to file a petition with the circuit court to get authority to do something. Because doctors don't like to go out on a limb. Hospital administrators do not like to go out on a limb and make decisions. Because every time they make decisions of that type, there's always liability of some sort attached to it. They want somebody else to make the decision, somebody else who knows you and his family and has your best interests at heart. If you don't do that with a written form, then it's going to be more expensive because, again, you're violating my golden rule. You have to go to court, hire a lawyer, and it's talking court costs, attorney's fees, time, and how do you know what the court's going to do? The judge may be a die-hard Catholic who is steeped in all of these Catholic principles, and he'll make a perfect decision for you. Or it could be a Unitarian or a Hare Krishna or someone who's an atheist who says, "I really don't give two plugs." You never know who's going to make a decision. And so when you are able, as we all are here today, to make your own decisions, you should do that. You should make your own decisions and provide for these things so you avoid going to court. As with the durable power of attorney, yes, sir.
Statute number again on the living?
Chapter 765, it's under the civil rights title of Florida statutes, and it deals with medical care directives, advanced care directives, living wills, and so forth. But it has a standard boilerplate declaration of right to decline life-prolonging technology, and it has a lot of other features in there. For example, hospital workers and social workers and retirement homes are not allowed to participate in preparing these things or witnessing because they may have a conflict of interest. Kind of like in Suwannee County, before we had, way back in when the earth was cooling, before we had an EMT service, you know who our rescue people were? The funeral home, right. And now if you get in the back of a funeral home hearse to go to a hospital, he may say, "Hey, I think I'll stop for coffee and get a donut or something before I get Decker to the hospital here." Not necessarily the best thing. So if you can make your own decisions, and to answer your question before, as with durable powers of attorney for business, financial checking, your health care should name, wives should name each other and have your children in succession if, your children are adults and able to make those decisions. But you need to have somebody in place that loves you and knows your values, knows your principles, knows something about your health, knows something about what you would want or not want, so that they can make effective decisions. And having this in place is not just for end-of-life decisions. One of the examples I give clients in my office is, suppose, that my wife has been in a bad accident. And so she's had a bad knock on the head, and she had a ruptured spleen. And she's also had some scarring or disfiguring injuries. If I'm laying on too thick? Yeah. But anyhow, but she's had those things. And so the doctors say, well, she's had a bad concussion, so we're going to induce a coma to protect the brain. And so she'll be okay, she'll come out of it, but for the time being, she's incommunicado. Well, the doctors then say, well, we need to do a splenectomy because she's had a ruptured spleen. And, she's had some scarring and she's got some cuts and bruises on her face. We may need to do some plastic surgery. And so if you have a healthcare power of attorney, then, whether you're a husband or a daughter or whoever, you can make decisions to say, we need to do a splenectomy because that is critical. We have to do that right away. So I'm authorizing that. But on the plastic surgery, my wife will probably want to use the one that Catherine Zeta-Jones was using, so we'll defer that for a while. So when she comes around, she can pick her own plastic surgeon, because that can be pushed down the road. So, but it gives you discretion to make decisions and to help people take care of things. Because otherwise, I'm telling you, there's mass confusion, there's mass hurt, and no one knows what to do. And while we're on these two topics of the power of attorney for business, financial property, and healthcare decisions, one thing I want to make sure I talk about, please, whatever you do, don't tell your lawyer when you go to talk to him about this that you want these two people appointed to act jointly. That's a big mistake. I've had several cases in the past 3 years where there were two agents handling business things. And in one case, the last case, I had two brothers who all their lives loved their daddy, and all their lives despise each other. And they could not agree on anything. So we had to file a petition with the court to get approval to do certain basic things that were supposed to be provided for in the document. But there was a deadlock. And the banks and the finance companies and everyone said, when you all figure it out and agree and tell us, then we'll do it. But until then, we're not doing anything. And that's absurd. And so that's a big problem. That's a big problem. My experience with families and people, especially on healthcare decisions, is that whoever you name as first or second or third, whoever you name first, let's say, they're not going to make a decision on their own without talking to everyone else in the family, the people that are second and third, with their pastor, their priest. They're going to talk to a lot of people before they make basic decisions, because it's a tough thing to do. It's a tough thing to do when you're calling the shots for someone who is in that kind of condition, and you may be making a decision that'll result in their life ending. No one wants to do that on their own. We want to consult. We want to make sure we have as much input as possible. But if you make it joint and say, well, I'll make it collegial, you may think it's collegial. It's going to be deadlocked. It's going to be a big mess. And it's also going to lead to you violating my golden rule, because somebody has to go to court and have a judge decide. And every time you go to court for a judge to decide, it's expensive and it's time consuming. And usually these things always happen when time is critical. Time is of the essence. And you don't have time to go through the court system. And if you don't know this already from any experiences you've had, judges don't drop everything they're doing and listen to your case first. They'll try to get to it as soon as they can, but there are a lot of other things that are in the pipeline. So when time is of the essence, you need to have something in place. If you don't have it in place, you've got a problem. Yes, sir.
I thought before your conversation here that a married couple, for instance, that my wife would have, she would make the decision for me automatically. That would be what it would be, right? The wife would make the decision, or I would make the decision for her. But now I'm hearing you're saying get the durable health care power of attorney, even if you're married. I would still have to name her as, it's not taken for granted that she has that power, even though we don't have it.
If you have no document, Chapter 765 says here's where we look to. We look to in order of priority the spouse, children, so forth. If you do your own written power of attorney, you execute it, you can provide anyone you want. For example, a couple of months ago, I had a lady come in, and she did not want to name her husband because her husband has dementia. So she named her son, and then her daughter, and then her second daughter. And then, we weren't able to do anything for the husband to update his. He had named his wife and the children on his previous one, but we were modifying some things for the wife. And so she didn't have to name her husband. You can name anyone you want. And usually people do name their spouses. But suppose, one of the things about practicing law is that you always have to assume the worst and work backwards. And a lot of times we're talking to people that may be thinking about divorce, or may not trust their spouses, or may have some other issue, or may feel that their children are not responsible. They don't have fiscal responsibility or moral responsibility. And so you don't want to go by that statute, because you may be putting someone in line that is absolutely a travesty. So, but doing your written, document now while you're competent and you can think through it, that's the time to do it. And under the law, you can name anyone you want. It doesn't have to be your spouse. For self-preservation purposes, I'm probably not going to name my spouse, but no, just kidding. I'll pay for this when I get home. Don't worry about it. But seriously, these are things that you should think through because they're very, very important. Any other questions about the durable power of attorney for financial things and the durable power for healthcare matters? Because I hope you can see that these things are part and parcel during those last phases of our life in preserving your estate, preserving what you've worked and accumulated so that you have something to work with for an estate plan. Because otherwise, all the things I'm talking about are going to cost money. They're going to cost legal fees, court fees. They're going to lead to mismanagement or no management of your assets. And so it's important to have these things taken care of. If we're good on that, we can always come back. I'll talk about wills and trust and so forth. Yes, sir.
Are financial institutions required to accept the power of attorney?
That's a good question. The financial institutions live in dread of getting sued by someone because, as Willie Lomax said, that's where the money is, and so people like to sue. But under Chapter 709 applies to durable powers of attorney for business, financial, and property matters. And under that statute, financial institutions, title companies, banks, you name it, they are required to accept a durable power of attorney that is properly executed. Properly executed means it's a written document. It contains the granting language provided for by statute. It enumerates the powers and responsibilities that you're delegating, and it's witnessed and notarized. Okay? And now they have to accept that. They're entitled to request that the agent who's presenting it sign a current affidavit that is still in force and effect and has not been revoked. But apart from that, they have to accept it. If they don't, then they're liable for damages. They're liable for the consequential damages that could develop from the inability to make a timely decision. They're also responsible for paying all of the agent's attorney's fees in enforcing that power of attorney. So the legislature, got a lot of feedback when they first wrote this law that banks were not following it. One of the first cases I had in the early 80s, I had a client that authorized her sister to take care of anything whatsoever. Anything whatsoever. Now, that's pretty comprehensive, you would think. Well, that's what it says. So her sister developed dementia, and she had been taking care of her bills and everything, and she said, I'm taking care of things for my sister now, but what happens if something happens to me? There's no one on standby. And she said Barnett Bank at the time had what they called their Barnett Bank Smart Trust for nursing home patients. They would pay their bills and make sure that their health insurance premiums were renewed, their apartment rent at the facility was renewed and paid, and all that sort of thing. And they would do that for you. So my client said, I took this document down to the bank and said, I want to set up a Barnett Bank Smart Trust for my sister, so if anything happens to me, you all can take care of it. And they looked at it and said, nope, can't do it. And she said, well, why not? It says I can do anything whatsoever. Well, it doesn't say you can set up a Barnett Bank Smart Trust. And so you think, well, wait a minute. Isn't that under the category of anything whatsoever? And the bank officer said, sorry, I'm not doing it. Our legal department in Charlotte says no can do. So then what we had to do, believe it or not, we filed a petition with the circuit court and had our circuit judge in 83, 84 sign an order saying the phrase anything whatsoever includes a Barnett Bank Smart Trust. And she took it to the bank and they said, okay, we're good now. But, she had to go through all that rigmarole just to get that done. It's ridiculous. And so, banks, were really creating a problem initially with this law. And some of them were a little bit more overzealous and picayune. So the legislature provided some teeth to the law so that banks have to follow this. They have to honor it right away. Does that answer your question?
Yes, it does. Not every state's that way.
Yeah, well,
Florida is.
But we've got a lot of old geezers down here, so we look after ourselves. But let's talk about estate planning, wills and trusts. A will, very simply, is a written document that says, I'm appointing this person to carry out my wishes, and I want them to do the following things with my estate. Real simple. And after that, you can make it as simple or complicated as you want. It has to be in writing. It has to be signed by the person making the will at the very end. It requires 2 witnesses. Under Florida law, in addition to the 2 witnesses, if it's self-proven, that is, the person making the will and the 2 witnesses appear in person all at the same time before a notary to say, we did all this at the same time, in the same place. The person who was doing it was competent. They knew what they were doing. They were over 18, and we all witnessed this will in accordance with the law. That will becomes self-proving and will be admitted to probate without any further muss or fuss. If you don't have a self-proving will, then you have to locate the witnesses and get an affidavit from them saying that they did all this. And one of the key things about a will is the people who are witnessing it have to witness in the presence of the person making the will and in the presence of each other. So if you do a will at home, you're going to save money. I love shade tree lawyers. They make more money for me screwing things up that I have to straighten out. But if you say, well, I'm just going to download a will and I'm going to print it, I'll fill out the blanks and I'll sign it and I'll take it to work and have this secretary sign it and this one sign it, that's not a valid will. Not a valid will. Because they did not see you sign it in their presence and in the presence of each other. One of the cases I had in law school was a person who, the nurse drove them up to the bank and they got in line at the drive-thru. And there was 2 people behind the glass in the drive-thru. And they said, I'm going to sign my will. Here, I'm signing it. You see me signing it? I'm going to put it in a little tray, and then you all witness it and then put it back and send it to me. Well, there was a challenge by one of the family members who was not in the will, obviously, who said, well, it was not signed in her presence because she was in this vehicle, and they were in a room, in a different room, sealed off. So that's what can happen when you have challenges to these things. You have to make sure it's executed in accordance with the law. Why is the law so strict? Why is the law so picky-in? It's real simple. Because you're disposing of all your worldly goods. And you're not going to be around to tell us and explain to the judge what you intended, what you wanted, and in fact that is exactly your genuine will and testament. And so we have to go by the document. And the law says it has to be executed with the utmost formalities to assure that it is authentic, that it was what you intended, and that it was done with proper instructions so that we can act upon it. It's for your own protection, for the protection of people that you want to leave things to, because otherwise a lot of mischief can happen. And so the law requires it to be done in a certain way. Your will gives you the opportunity to do a lot of different things. If you're a young couple and you have some children, minor children, you can designate who you want to serve as your guardians for your children, who you want to raise your children if you both have passed away because you're not there. And do you want maybe a brother who spends all his time at the racetrack being the guardian and raising your kids? Or do you want the one that comes to St. Madeline every Sunday? I know it's a toss-up, right? But you want to make sure people who will have your values are going to raise your kids the way you would raise them. And it gives you a chance to do that. Now, the person you would name for a guardian, because they have good values, they're very nurturing, they're good parents, they may not be very good financially. So you may want to name someone else to take maybe insurance proceeds or your estate and act as trustee for your children. These are all things that you have the right and the ability to do if you do it ahead of time and think through it. But if you don't, then again, without a will, without any understanding of what you would prefer and what your values are, it's left to the discretion ultimately of a judge to make these decisions. Now, the judge will get input from all these family members, and sometimes we're all on the same page. And sometimes, a lot of times, they're not. They're in conflict. And the judge has to figure out who's telling the truth, who's lying, who's got an axe to grind, who's got a self-interest, who has the best interests of the kids involved, and make the best decision that he can. And, you know, the judge has got a caseload like this, and he's looking at all the people in the hallway lined up to hear cases, and, you know, he's not going to take yours home and pray about it for a month or two before he makes a decision. That's not going to happen. So you can do that. You can make those decisions and make sure you provide it for your family the right way. Maybe you're older and you have an adult son or daughter who has substance abuse problems. Maybe they're great kids, but you know, we have a joke in my family. My sister, I love my sister to death. She's a great woman. She teaches over at St. Mark's Day School. Lovely woman, but she's lousy at picking out men. And my sister and I told her, you're not allowed to pick out any more husbands. If you want to get married again, we'll let us know and we'll find you someone. We'll get you a mail order groom from Romania or something, anything. But you're not allowed to pick them out because you're just incompetent to pick out men. You're good at picking out no good men, but you're not good at picking out good men.
Does power of attorney cover that?
What's that? What's that?
Power of attorney cover that?
Unfortunately, no, it doesn't cover that. But you might have a child that is very irresponsible. You can set up a spendthrift trust to make sure that during your lifetime, if you provide for them and help them out financially, but you do it in a measured, logical, and carefully controlled way, that's one thing. But when you're not here, how do you do it? How does it happen? You just give them everything on a platter day one, and they blow it? Or do you have somebody set up as a trustee to dole it out carefully in a measured way for their best interest, for their health, for their welfare? Maybe you have a child with special needs. I've represented clients with children that have never been able to walk from childhood, severely autistic, and they worry what's going to happen to our child. We're taking care of him now. He lives with us, but we have to do everything. They're like babies. You have to change them. You have to do everything. But we're dead and gone. What's going to happen? Well, if you want to have federal or state assistance, they look at what your available resources are. If you set up a special needs trust under the terms of your will, the will can incorporate testamentary or special needs provisions, then you can provide for that. You can secure that money and save it for enhancements for that child, things that are above and beyond what the state provides for, but call upon and use the resources of the state. Because after all, if you paid your taxes for them, why shouldn't you get the benefit of what you paid for? And why should you also not be able to preserve your estate for that child, for special enhancements that they might need, things that aren't covered by Medicaid, or maybe preserve it for other children who may need something down the road. But it gives you the opportunity, if you want to be morbid about it, to rule from the grave and control what happens. I like to look at it from the point of view that you are still being a loving parent, you're still being a nurturing parent, you're still being a responsible steward with what the Lord has given you and blessed you with. And it gives you the opportunity to make the best decisions for the people that are going to survive you. But it gives you the chance to do all of these things, whether it's through a will or a trust. Now, a lot of people ask about trust because everyone has got the idea that if you set up a trust, then it can never be challenged and you don't have to pay taxes. That's not true. If you set up a trust, it's still going to be subject to taxes if it's over a certain threshold. Right now, under federal law, it was $10 million. They indexed it for inflation a couple of years back, so it's like 13 or 14 now, I think. But unless your estate is over that, then you don't have to worry about it. There are no estate taxes. There are no inheritance taxes. Florida has an estate tax, but it's set up so that if you're exempt from federal taxes, you're automatically exempt from Florida taxes. And so if you're over 14 million, that's a problem. But that's a good problem, right? I mean, 14 million, that's pretty good. That's not a bad problem to have. The other thing I want you to understand in terms of estate planning and giving is do not give an asset to your child now. Don't say, well, I don't want to leave it through my will. I'll be dead and gone. I can't enjoy them watching it. I can't exact the maximum amount of Jewish guilt on my kids by giving it to them ahead of time. Giving a will. I want to give it to them ahead of time. I want them to thank me every day and be obsequious about this gift. So I want to enjoy that. Don't do that. Don't do that. If you bought that asset for $100,000 years ago, and you give it to them, now, and then you die, and 5-10 years now, they're going to sell it for $500,000. Okay? The day you die is worth $500,000. They're going to pay capital gains on $500,000 minus $100,000 because their basis in the property is your basis in the property. Now, if you give it to them and leave it to them through your will, then they get a stepped up basis. If the value is $500,000 on the date of death, that's their basis. And if they turn around a year from now and sell it for $520,000, $550,000, they'll pay taxes on $20,000 or $50,000, but not $120,000, not $420,000 or $450,000. And they'll get a stepped up basis. And now I will tell you, for the past 20 years, every Democratic administration has talked about doing away with the stepped up basis and doing away with the estate tax credit and then dropping it back down to what it was way back when. When I practiced law out of law school, it was $600,000, which hardly covers anything nowadays with inflation. And it's up to 10, but they want to talk about cutting it back. Every administration, Democratic administration, has talked about doing that, and none of them have had the guts to do it. Because, as you can see, people would scream bloody murder. It was just not fair. So, not picking on Democrats, but they're the ones that have pushed that. And so that's something to keep in mind, but frankly, I don't think it's something to worry about because I don't think it's ever going to happen. I think it would be political suicide if any party ever tried to do that. But my main point is, don't give children a gift during your lifetime unless you can do it in a smarter way than that. But if you don't, if you give it to them in their lifetime, your basis is going to be their basis, and they're going to be penalized for that. Your estate planning also allows you the opportunity to remember St. Madeleine or the Catholic Church in your giving. Every week we tithe and we take part of what we make for our families and ourselves, and we give it to our church. We hand it up to the Lord for Him to use and to put to good work for the works of our community, for the works of charity, for the works of our beautiful facilities here. Those things continue on. This gives you an opportunity to keep faith with the ones that came before you who were generous and who gave and left something. You can do that without shortchanging your families. You can do that in a way that will help. A lot of people set up charitable uni trust remainders where they give a certain amount, and the church will get that when they pass away. They're allowed to draw a certain amount of income during their lifetime. There's all sorts of different packages and estate planning vehicles for doing that. You should really have a CPA help guide you with that. But there's a lot of ways for you to remember your church and to help continue the ministries that are so vital. There's so many things that we take for granted to receive the Holy Eucharist, because that is the source and summit of our Catholic faith. There's a lot of just really day-to-day humdrum things that have to go into that experience, to that sacrament. The lights, the air conditioner, the yard, the facilities, the air conditioning, hymnals, sheet music. There's a lot of things that go into it. Salaries. We have an office staff that works hard to put together bulletins, keep us informed, and to handle things administratively that we don't worry about during the week. Those things have to be provided for. And this is your opportunity to be part of that and to support that. And that's very, very vital to our church. And I would certainly encourage you to give that very, very prayerful thought when that time comes. A trust is different from a will in this sense. When you set up a trust, and the main reason why people set up trust is, besides wanting to protect their assets from a spendthrift child or a child with substance abuse or a child with special needs or whatever, is that that you want to avoid probate. You want to avoid probate. If you set up a trust is a separate legal entity. It's like you set up a corporation, and then you're the sole shareholder, and then you transfer everything you own into that trust. The title to your property, the title to your bank accounts are all in that trust. Now, because you're the sole shareholder, you're the sole trustee, you continue to manage it, control it, and operate it. No one else does, you do. And then when you die, you can have a successor trustee in place who acts similar to an executor, okay? And then the executor has to look at two things. If you become incapacitated during your lifetime, the successor trustee looks at the trust and says, my job is to use this money for the best interest, the welfare, maintenance, support, education of the person I'm taking care of, the person who formed the trust, you. And then when the person dies, they look to the next paragraph, well, what do I do now? And it could be something simple like, it goes to my 3 children, share and share alike. Okay, I'm going to liquidate everything and write 3 checks. Or it could say, I was supposed to handle it and administer it and distribute it in a scheduled, measured way over a period of time. When I have clients with children who are minors or children who are just barely adults, what we typically do is we'll say that upon my client's passing, the trustee's job is, until they're 30 is to administer the money for their best interest, for tuition, for textbooks, for education, maybe help them with a down payment, medical care, things like that that are necessary, because we want to make sure that child actually goes out and works for a living and gets out in the real world and finds his or her own way. And then at age 30, they get 25% of the corpus, 25% of what's in there. And then at age 35, they get the rest of it. And my theory, and I've always shared with clients, is from 18 to 30, kids, just based on my own life history, being a knucklehead from 18 to 30, the kids are not that mature. They're not that responsible. They're not that wise. Plus, from 18 to 25 or 30, we want them to work. We want them to be hungry. We want them to push and get their education and get a graduate degree and get a good job. We don't want to hand them things where they say, I don't have to work. I can just kick back and relax. Also, what happens in between 18 and 30? Huh? They get married. They get married. And what happens when they get married? One of two things happens. One of two things happens.
They live happily ever after, or they get a divorce.
Yeah, that's exactly right. So, do you want your trust money getting pulled into a divorce case and up for grabs? No, you don't want that. If they're going to go through that, sad to say, but they're either going to make it or not. And statistically, a lot of marriages don't make it. But you want to say, well, if they get to age 30, kind of like my experience with my wife, she resisted the temptation to poison me for those years. And so, we were good to go after that. She figured, hell, he's worth more to be alive now than, so she kind of tabled those ideas for a while. But, you want to wait and see that the marriage is stable, that it stood the test of time, because every married couple has what I call a shakedown cruise. I mean, they have to get used to living with each other, because it's really difficult for two independent, smart, intelligent, strong-willed people to live together. And so they have to figure out how to work things out. And for some people, I don't know who they are, but for some people it happens naturally right off the bat. For others, it's a process. But you don't want that tied up and pulled into a divorce case. Now at age 30, my theory behind giving them 25% is that, again, one of two things will happen. They'll either take that money and say, I sure appreciate this, Dad, wherever you are, and I'm going to handle it wisely and prudently. I'm going to invest it. I'm going to handle it, and I'll patiently wait until I'm age 35. Or they'll blow it. They'll blow it. But they have 5 years to think about how hard that was to come by, and the next time they get their hands on it, they're going to hold on real tight. Be careful. That's just human nature. You know, you try to anticipate human nature and head it off if you can. Because if you were still alive, what would you do? You know, you wouldn't say, well, here, son, let me give you everything I've got and let it get tied up in a divorce case. No. You wouldn't say at age 30, well, here's a whole kit and caboodle. I hope you're smart with it and handle it correctly. No. You say, I'll test the waters. I'll give this kid a little money and see what the knucklehead does. And, you know, if he screws up and blows it, well, you're not going to see any more money till a couple of years from now, down the road. And we'll see how you do then. But this is the chance for you, who are no longer here, to set things up and set people up as trustees, as people who are managing it, to be able to do what you would do if you were still here. This is part of estate planning. It's part of thinking through. Each one of us has a personal, unique family and financial and home situation. And you're allowed to fine-tune it any way you want. You know, sometimes clients will say, well, here's what I want to do. Is that legal? I said, you can do anything you want with your money. It's yours. My job is to make sure I put down in black and white writing exactly what you want, so the judge will say, yep, we'll do it. And he'll issue the order and get it done. Real simple. So, but, you know, that's how an estate works. Now with the trust, since everything's already in the trust, when you die, there's nothing to probate. You don't own anything. The trust does. And so your successor trustee can just liquidate things, pay any remaining bills, and distribute it to your beneficiaries. It doesn't go through probate. Yes, sir.
Short of setting up a trust, is probate always required on your demise?
When you set up a trust, probate, generally what you're striving for is no, you don't want to do probate. You want to avoid probate, and you're hoping the trust will take care of it. Now, there are some assets, and again, this is where we get to particular instances that you can't rely 100% on what I'm saying. And I'll give you an example right now. Let's suppose you have a bank account or a house. Well, your trust says liquidate it, sell it, put it on the market, get all the money. You got 3 kids, you got $90,000, write a check for 30 to each one of them, you're done. No probate. But suppose that decedent has an IRA for $100,000, okay? And do you want that liquidated and distributed? I would say no, because once you do that, when you do a sale or a transfer or anything like that, it triggers recognition. The IRS loves to have things triggered so they can recognize gain or recapture of something that was tax deferred. And so if you have an IRA, you don't want that to go through a trust or a will to be liquidated, sold, and distributed. Instead, you want to name as beneficiaries under that IRA account the beneficiaries you want, because one child may say, I want my cash right now, I need it. Well, they're going to pay the penalties that go with it. Another child may say, I'm still working, I don't need the money, I want to roll it over. And so they'll just roll it over, and it continues to grow tax deferred. But the last thing you want to do, if you can avoid it, is just liquidating certain types of assets like that and allowing the IRS to come in and really tattoo you with taxes on the part that you were sheltering and tax deferred, but are now going to be recognized. You don't want that. So, but those are all things that, on a case-by-case basis, talk to your lawyer, talk to your CPA. There's always a smart way to handle it, so you get done what you want to get done, but you get it done the smart way. But remember, it is perfectly legal to do anything you want to avoid taxes. It is perfectly illegal and will send you to jail along with Al Capone to evade taxes. The tax evasion is a no-no. Tax avoidance is smart. Everyone tries to do tax avoidance, but you got to be smart. Don't do tax evasion. Okay? Now, there's some things you can do that are sort of a hybrid between a will and a trust. Most lawyers will tell you that a will is relatively inexpensive to do. A will package with the durable powers of attorney and a will, relatively inexpensive. A trust, usually more expensive because there's a lot more work involved. There's a lot more instruments. So you have bills of sale, you have deeds, you have a lot of other title transfers you have to work on. But there's a way to try to avoid the expense of a trust and still have your cake and eat it too. And a lot of people, for example, will do what I call ladybird deeds. Who in here has heard about what a ladybird deed is? You ever heard the expression ladybird deed? Okay, we have one or two. Sometimes it's called enhanced life estate warranty deed. And normally a plain vanilla life estate deed, I sign a deed right now and it says, I'm transferring this to my son, but I'm going to keep a life estate. But once I do that and it's recorded, my hands are forever tied. I can't change it. You know, the only way, suppose I say, well, I want to put a mortgage on that property, I need money. Or I want to sell it, I'm going on a cruise. And my son says, no, I'm not doing that, Dad. I'm just going to wait till you die and I'll get the whole kit and caboodle. I don't think you should have any money. I don't think you should take a cruise. That's my inheritance. You're going to blow it. So no, tough. So there's nothing you can do about it. With an enhanced life estate deed, you retain total control to revoke, to amend. You can sell the timber off your property. You can mortgage the property. You can do anything you want with that. You can change the grantee. Instead of your son getting the remainder interest after your life estate gone, you can name someone else. But you maintain total control. Now, how is this a hybrid between a will and a trust? Your will may deal with things that have to go through probate to a limited extent, but your main assets, like real estate, which always have to go through probate no matter what, you avoid that asset going through probate because you've already set it up to be automatic. Once you die, with an enhanced life estate deed, that you retain the ability to revoke and control and amend, all your son has to do is go down to the courthouse and record a death certificate, and the title company says, it's yours now, kid. There's no need for probate, no need for anything else. And so it's a way to avoid probate on assets that have to go through probate, like real estate. Now, on my bank account, I can avoid probate by simply doing a designation called, it's either transfer on death or payable on death. Different states call it different things, but I go to the bank and say, I've got an account. When I die, I want it to go to my son, or my son and my daughter, share and share alike. They go, okay, we put their names and their social security numbers on there, and it's going to be automatic. All they have to do is go down there with a driver's license or a passport and a death certificate and say, dear old Dad's croaked, and we're the kids, and so cut 2 checks, and that's it. No probate lawyer fees. So it's an effective way and to get estate planning done. And if you're asking, well, if you're doing all that, why have a will? The will is a safety net. It's a backstop. Because I've had cases where we thought we'd taken care of everything, the family had taken care of everything, and we'd find out there was some relative or some company in Arkansas, actually the case was in Arkansas, where they left some property to the decedent, but it had to be probated, it had to be a will. So we had a will in place so we could do that effectively and quickly and cheaply. But without a will, we'd have to go through everything from scratch out in Arkansas. And that would have been more expensive. But with the will that we did, all of those decisions, who's going to be the personal representative, who is going to handle things, who are the beneficiaries, all of those things were laid out. Now, if there was no other property anywhere else to account for, then what we did would be fine. We avoid probate and it's all done. But we needed a will as a safety net or a backstop, if you will. So, I hope I can leave you with the idea that, and this is a word that we hear a lot by certain people in the national news who will go unnamed, but this is sort of a holistic approach. We talk about, the phase of your life where you're still with us, you still have relatively good health, but, you're not too with it upstairs and you can't handle things. We do not want a guardianship. We don't want to go to court. We want to have effective financial help by families that we trust without going to court. A durable power of attorney does it. It preserves wealth. It makes for effective decision making. We also want to make sure that we have a durable health care power of attorney so our health care decisions are made appropriately. And we avoid going to court. We avoid delay in treatment or other things because the doctors and the nurses don't know who to deal with. Or they're getting conflicting signals from people. Like suppose you don't have a surviving spouse, you're not married. You got 2 kids. Son wants to do this and daughter wants to do that. Who do they listen to? They'll say, you guys make up your mind and tell us what you want and both agree on it or get us a court order. And I always say we don't want to go to court if we don't have to, because it's a waste of money. It's a waste of time. And then a will or estate planning for your estate. And for what you worked so hard to accumulate, And for those that you love and want to provide for, whether they're your young children who are not adults yet, or children with special needs, but especially, your church, these are things that you can take care of and provide for in your will to make sure that your wishes are honored and taken care of effectively by someone you trust to carry out your instructions. And so that's all part of estate planning. Every case is different. With some people I've had one client, a bad family history of strokes, long-term nursing care. And so we did an irrevocable trust for her and put everything in the trust and then prayed we'd get past the 5-year look-back period. Well, we did, and she qualified for Medicaid assistance. She was able to preserve her estate for her children, and she was able to, take advantage of Medicaid assistance. And so there are things like that you can do under particular circumstances. But the bottom line is you want to responsibly, you want to be good stewards of what you've accumulated in your lifetime for the sake of those you love and those that have meant so much to you. And certainly our families mean a lot to us, and our church means everything to us, everything. And so we want to make sure they're provided for. And this is the way for you to do it. I'll leave you with this final thought. I've never had a client come in and do estate planning and then drop dead. For some reason, people think if they do a will, they're going to die the next day. It doesn't happen. It doesn't happen. It won't happen. Trust me. But I can tell you umpteen cases where people come in and it's an ungodly mess. And, the parents have lived here for a while. The kids are in Oregon or Timbuktu. They have no idea what dad and mom have been up to or what's going on. And they got to sort it all out. No will. And so that's a problem. Also, you need to make sure that your estate papers are handled securely. Get a safe deposit box or have your lawyer hold it in his safe deposit box. Okay? I had a case not too long ago where this couple in Madison, they owned 110 acres on Old Blue Springs. It's choice prime real estate in Madison County. I mean, just choice for subdivision development. Probably worth about $700,000 or $800,000 at the time. And they left it, they had no children. No children. They left it all to the boys' ranch. Because they were very active in the boys' ranch. They went to all the functions. They loved the orphans out there. They took care of all that. And they died. They both died, but then, a couple of weeks of each other. And so, the boys' ranch said, well, they told us they left a will. They left everything to us. And so, we just need to get the will and probate it. I said, okay. And so, come to find out, there was no will. Could not be found in their house. They had a nephew who was absolutely rotten. This guy was a druggie. If he had an extra dollar, he'd use it on drugs or prostitutes or anything. The guy was horrible. And we were convinced he got into the aunt and uncle's house when they died and he found the will and destroyed it. So as a result, they died without any children. Their parents had not survived, no brothers and sisters. So then it goes to nieces and nephews. One nephew survived, this guy. And so he stood to get all the money. And so we litigated that for some time. We settled it finally by getting about 25% of the money. I didn't really have a leg to stand on, but they had no will. And if you don't have a will, Florida intestate law writes a will for you. And by the way, if you're involved in second marriages with stepchildren, you definitely need to make sure you have a will, because otherwise you may have stepchildren that you don't care for at all, but they're going to get half of everything you have to the detriment possibly of your children or the surviving spouse that you love. But anyhow, this nephew got a hold of everything, the bulk of it, and it was just really something. I remember going to their house to do my own search, and I pulled out all the drawers, and I got to one drawer, pulled it out, and I reached my hand back there, and there was a lot of paper. I was hoping that maybe that will had fallen behind a drawer. It was back there somewhere. And I knew there was no hope that he'd gone through and found it. But anyhow, I felt some papers back there. I started rustling them, and I pulled the paper out, and I shielded this guy and his lawyer from me. And I was looking, I said, oh my God, here it is, here's the will. And the lawyer told me later, called and said, "You about gave my client a heart attack. He thought you found the will." And I said, "Well, thank you for telling me that. That tells me that's SOB. He stole that well and destroyed it." But you got to make sure that's secure. Make sure it's secure and well protected. The good news of that story was he had a daughter and a granddaughter in Arizona that were totally estranged from him and thought he was scum of the earth. Well, he decided to go to New Orleans and have a grand hurrah with his money, doing all the things you would think you could do on Bourbon Street, and died in a hotel room in New Orleans. And so the daughter and the granddaughter wound up getting all the money. And my client, the president of Boys Ranch, said, "I'm happy with that. I can live with that. They deserve it. They need it. They're a single mom, a lot of problems. That's fine and dandy, as long as that guy didn't get it. But sometimes that guy winds up getting it, and he winds up living a long time. And you're up there in heaven looking down like, oh my gosh, what can I do about it? And the answer is nothing, nothing. Okay?
Shouldn't they have taken that will and put it in a safety deposit box?
Yes, thank you.
Told the Boys Town place that if something happens to us, we die, that's where the will is?
That's right. Now, what I do in my wills, because of similar experiences way back when, the wills I prepare has a provision that says, because there's a presumption under Florida law that's really stupid. And this becomes a great shock to you to realize that there are things in the law that are stupid, but trust me, there's a lot of things in the law that are stupid. But there's a presumption of the law that if you do a will, and then we can't find it, we presume that you revoked it by destroying it. Which encourages people to steal wills. If you're trying to cut somebody else out, right? So my will say that I don't want that presumption to apply. I'm negating that presumption. If I want to do a new will, I won't destroy this one. I will do a new will. And the new will say in the preamble paragraph, I'm revoking all prior wills. This is the will. So it says that if you can't find the original will, you are not to presume I destroyed it. Instead, you are to presume that the scanned copy that my lawyer has on his hard drive and a paper copy which he has in his file will be deemed the original and be entitled to probate upon me signing an affidavit as a witness that yes, that was his will, yes, I witnessed it. And we've done that several times when we couldn't find a will. And it's a huge, huge lifesaver. But otherwise, you're right. Bob, I screwed up. Otherwise, if you don't do that, put your will in a safe deposit box to make sure it's safe. And that way, your wishes will be honored. Are there any last questions before I turn it over?
Andy, just a quick question. This goes to charitable contributions. Can you make designated gifts within that particular organization?
Yes, I have a lot of clients who will leave to specific things, maybe Knights of Columbus, maybe they'll leave it for certain ministries. They'll say, clients will say, I'm leaving it to St. Madeleine, but I don't want to go for operating expenses. The people like us sitting here today, we can pay for our own AC on a week-to-week basis. I don't want my money going for operating expenses or overhead. I want to go to ministry, maybe the Respect Life Apostolate. Maybe we're trying to do renovations on the Activity Center, which I think we're going to have a part the Red Sea miracle to get that happening. But you want to leave money for that to develop to finish that type of construction, or maybe you want to leave it to the shrine for the shrine facility for things that are going to be done to enhance its operation and support its ministry, support what it provides for the whole diocese on this western side of the diocese. You can do that. You can designate specific things.
And then what happens if you die in 10 years in that particular area? Let's say community outreach, for example, you left it there and it no longer existed. Would that gift go into then the general parish operating expenses or fall back into your will?
Well, what my clients do is they have something on standby. They'll have something that they know or they think they know will always be there. There will always be certain types of ministries, certain types of functions, no matter what. But if you don't designate anything in particular, then it'll just go into the general fund. So, any other questions? This is, I see all these people, and I'm just beside myself in total anguish, thinking, all this billable hours I could have had. But this is your chance to ask questions and get free legal advice. Or, no free legal advice, but information. Okay?
Didn't you say you could refer us all to other attorneys?
I don't have a sheet on that, but I think Kelly's got something on that. And there's a fellow, Brent, I forgot his name, that's on the back of our bulletin every week. And there's several lawyers in High Springs. What I can do is for Father Sebastian Deacon, I'll get a list of the lawyers in High Springs, Alachua, and Gainesville. I'm not sure if any of you all are up toward the Lake City area, but there's some great lawyers there. Guy Norris at Epiphany Church, he does estate planning. Guy is a super lawyer, does a great job. He's really great to work with. But people like that, I'll get you a list of the names, addresses, phone numbers, emails, so you'll have that available, and we'll put that somewhere. Maybe Bob, if he puts this on the website, can put that or add that to it, so you'll have that readily available.
The page that talks about this
Okay.
event.
Yeah, that'd be helpful. That'd be good. I'm not here to solicit. I'm here to give you information and encourage you to go hire one of these lawyers and get this done the right way, because it'll save a lot of wear and tear. It'll give you peace of mind, and you'll know that the things you tried to do to the best of your ability as good stewards while you were alive are going to be carried forward and honored after you pass away. And I think that's something that means a lot to each of us. Thank you.
Thank you, Andy. We really appreciate the time that you've given us. And when you leave here today, a lot of you might think, oh, that was too much. I can't handle it. I'm just not going to do it. But the time is now, because the professionals are the ones who help us with that. I hope you leave here today realizing I've got to take care of business, and then understand the steps to go forward with that. And that's what a lawyer will help us with. My husband and I just recently updated our wills because we made them right when we were expecting our first child. Well, they're now all out on their own dime, so they're taking care of themselves. So we went back in, and it really is a painless process if you get the professionals who know how to do it.
It's easier than root canal surgery.
It really is, because when you pick the lawyer you're comfortable with, you sit down and they listen to what you want to accomplish. And then when they hear what you want to accomplish, what your passion is, they put all those pieces together for you. And they say, okay, this is what we need, this is how to go about it. And every one of us is different as to how we need to take care of our estate planning. And that's why they went to so many years of school to learn how to do all of that. And Andy's correct, the state of Florida is one of the toughest states for your wills and trusts, because we have so many seniors moving to our state. We have to try to take care of them with the laws that are put out there. At the foundation, we are passionate about helping take care of you, the parishioners, making sure you have all that in order, because as Andy said, you don't know, when it's your day to leave this earth, and we want to make sure that we have it all in order. Yes, ma'am?
Sometimes I see these videos and they talk about, like Steve Turley, for instance, has that title lock advertisement on there, because they're talking about how there's a lot of these people that go and they steal the title, and it's supposedly very easy to do. They'll steal the title to your property, your house, and by the time you realize it, or they'll get the title put in their name, and then they'll go and they'll use the equity on the property, and they'll go and they'll take out loans and stuff. But by the time that you figure out what's happened, it's too late, and then you end up stuck with the problem, and you have to pay the lawyer's fees and go through all that. So does that figure into that in any way, shape, or form?
That's title fraud as opposed to estate planning, and that does happen, but it's very rare, because any lender has to go through and do it. They have to do certain things under the regulations. They have to get appraisal, they have to do a disclosure, they have to get a confirmation of identification under different provisions of the Patriot Act that apply to banking institutions now. And so it's very unusual for somebody to be able to get away and do that without someone else. It's really hard to do that effectively. Plus, Florida law has changed. They've passed things that make it a lot easier to get those things canceled. I represented a clerk of the court in Suwannee County, who this guy was a sovereign citizen who was trying to take the judge's property and the clerk's property because they had made some rulings and done things he didn't like. And so we were able to get all that changed really quickly and corrected. And then we got the U.S. Marshals on them, and they finally tracked them down someplace in Mobile, I think it was. But it's a pain, but it's not that big a deal. It's not really something to worry about. The LifeLock, Title Lock, and all these things, they're selling a product, but I don't really know if it's necessary. The times when that happens are rare, and the times when it can't be fixed really, pretty readily are pretty rare. So, I mean, that's just my experience.
Yeah, somebody actually got away with trying to take the estate from Elvis Presley's estate. And who would think that they would have the audacity to do it? But he really did it. But they did get it back. They have money to pay for lawyers, so.
Well, I don't think that ever happened to me, and they got a funny deed and they tried to come and take possession of my house. Besides LifeLock, I've got another firm that takes care of that. It's called Smith & Wesson.
I was waiting for that. But that's part of having all of your house in order, because the lawyers and attorneys will tell us what we need to do to protect what assets you have, and each one of us have different assets.
If you click on your property appraiser's website for your property from time to time, like maybe once a year, twice a year, that's a quick and easy way to find out what's going on. But they'll show up there. So they put the change of title as part of the records for your property for tax assessment purposes.
Okay.
Yeah, regarding those public records checks, Florida has an expansive list of judges, cops, first responders that you can request to have your public records removed place by place. Does that, one, really screw up your will and force you into probate, or two, protect your house even better with this title fraud and title loss stuff?
Well, those are done for two reasons. So for people, bad people can't figure out really quickly where you live. And number two, sovereign citizens can't monkey with your assets. But it doesn't really have any effect at the end of the day on estate planning. I would call it a nuisance more than a problem.
Could you explain a sovereign citizen?
Sovereign citizens are people that don't recognize the authority of the United States of America or any state authority. They believe that because we got off the gold standard and some other things, that these things don't apply. They treat themselves as their own citizen. And most of them get something on the internet that's crazy. They file things in reference to the Uniform Commercial Code. They call themselves vessels. They're their own entity. They're their own person. And you can't talk to them or deal with them other than through their authorized sovereign representative. And when I was a judge, I had a lot of them come before me and tell me I had no authority to adjudicate them. I couldn't do this, I couldn't do that. And I explained to them that gentleman over there with the gloves on, who's inking up that machine, he's going to take your fingerprints and he's going to take you to jail, sovereign citizen or not. So, have all the fun you want. Now, some of them are just kooky, and they get themselves in trouble, and they wind up realizing too late that it was a bad idea. But some of them are downright dangerous, and I've seen videos that troopers pull them over to the side of the road, and they'll go up to get their typical speeding thing, get their license, and they get blown away. They're very violent. Some of them are really crazy. They're tied up with militias and everything else. But fortunately, those are very rare. And most of those people have figured out that it's a dumb internet idea that doesn't mean anything, and they quit.
Yes, sir?
At a trial, this guy was a sovereign citizen. He does a trial. He wanted to represent himself, and he got convicted by the jury. And then he fell on the ground, started bawling like a baby. That he didn't want to go to prison. And I said, you're entitled to have a lawyer. I'll appoint a lawyer for you. I'm my own person. I'm my own citizen. I'm my own country, and I don't recognize any authority to serve. Okay. because he has a right to represent himself under the
Did he end up
Constitution.
with his own cell?
Yeah, he got his own cell, not a sovereign cell, but it was a cell. But most of those people are just kooky, and it seems to be a fad that's gone away. I think a lot of it got triggered by the Great Recession of 2009, when real estate, banks, and everything collapsed, and there's a lot of crazy stuff out there.
Thank you. I think we have one more back there.
Yes, could you share what the average cost for a lawyer would be for the three types of estate planning that you provide? I mean, I know you don't, obviously there's no specific number, it's all based on your situation, but what would be the average cost of a will?
Well, I've always done, I can't talk for other lawyers, but for those three things, if it's a relatively straightforward and not a lot of complications, it's hard to say what are the complications, but for something, to answer your question, for a standard will package, let's say, it would be probably about $500. And that's well worth it. In my opinion, I lose money doing those, but I want to have people have wills, and I think it's important. And there's a little self-interest involved. If I do the wills and people die, usually the children bring them to me to probate if that's necessary. I try to do it so they don't have to probate, but if they have to have a probate, I'll do it. But people should have a will. I want people to have a will. It gums up the legal system and creates more problems than it's worth not to have a will.
And trust?
Trust, trust is probably something to look at in a very distinct minority of situations. People always think, oh, I need to be a trust because I read that you have to have a trust. That's not true. Sometimes a will do it.
Yeah, and most law offices that handle wills and estates, if you call them, most of them will give you the starting fee of their practice. They'll say, well, it starts here, you can go up from there. So you can take a look at that. But what Andy said, it's just so important for all of us to have a will. Like my oldest child, who has his firstborn child, they don't have a will. It drives me crazy. I go, just make a simple will. You know, who's that baby going to go to? I want to know. I mean, I know who I want him to go to, but there's another grandmother. And they go, well, it's obvious that you're going to get him. No, I tell them, I go, no, it is not obvious. That's our hope and that's our desire. But, you know, if we start battling, you know, the grandparents to grandparents, and it can land into court. And they're young, all right? All of us sitting here, we've lived a lot of life, and we have a lot of life lessons. So, you know, hopefully they'll come to it eventually. But
let me give you a comparison answer. If you have a will for $500, and let's say I also do a durable, enhanced life estate warranty deed to avoid probate for real estate assets, and I charge another, $150, $200 for that. That's $700. Okay. So $700 for that'll take care of things and avoid probate. Hopefully avoid probate. Now, if you don't do that, formal administration of probate is a $400 filing fee. That goes to the clerk of the court, not the lawyer. And most lawyers in our area have a minimum retainer of $5,000 for a probate case. Now, for a summary administration, which is a simplified type of probate, the filing fee is $345. And most lawyers charge between $1,500 and $2,000 to do that. But, even at $1,500, the cheapest plus $345, that's $1,845. So $600-700 compared to $1,845, not to mention the aggravation of probate. It's smart to do your estate planning ahead of time. It's smart, you save money, and you save aggravation, and your family will love you for it.
it's really the greatest gift that you can leave your family. We had a parishioner in Jacksonville who came in to see us because they missed a workshop that we had done and they really wanted an overview on it. She was one of 9 children, and her father had passed away 7 years before seeing us. He left no will. He had beautiful property, a lot of things, still not settled, and there was no end in sight because they hadn't done it. You may be as simple as, like my husband is like, most of our stuff is beneficiary upon death. So we really didn't have a whole bunch that we needed to, do other things for it. So, that wasn't a bad situation, dollar-wise, to take care of.
It's a 2007 probate case with about 120, 130 heirs. No will. There's 120 heirs because nothing was ever probated
Probated.
from generation to generation. And, you know, it's like 2, 4, 8, 16, 32.
It's crazy.
It keeps going crazy, and so, you know, have a will, please get a will. It makes it so much easier.
Yeah, and we'll provide, and I'm glad you can provide us some references in this area, because we really try to look and make sure we give qualified references when we do that from the foundation.
I would have to
And the
get it to the father and Bob so they can put it on there.
And then on the foundation, and my job at the foundation is twofold. I work with the parishes and the pastors to help spread the word through these workshops, and also help you, ask you to consider when you do your estate planning, you take care of your biological family, but consider your spiritual family, and how does that look to you as you make those plans. And then I work one-on-one with the parishioners. That has just been so joyful for me to do, because everybody is different, everybody has different wishes, but they all want to give back to their spiritual family, either a ministry or the parish itself or a school, and it just makes them feel so good when they do that. And Andy touched on something, when you put that will together, the 4-H, I think it was 4-H you referenced, you know, and we encourage people, if you're going to leave a gift to the Catholic Church, is in your folder. I just wanted to reference a few things in the folder, and then if there's no more questions, we can go. But this is what you can fill out so that we keep in a confidential file at the foundation about a legacy gift for the parish or whatever else it ends up being within the diocese, so that when we hear somebody has passed, we pull that file and we help follow that and make sure that your gift goes to where you want it to be. And I think you had the question about, well, what happens if something doesn't exist? Well, we also work with endowments, which that's a whole, I have a whole workshop that I can talk about the charitable ways through the diocese. But on endowments, when it's named purposes, if something were to, because I think many decades ago there was an orphanage in Jacksonville, and somebody had left an endowment to the orphanage, and then it closed. So the board of directors of the foundation spent a lot of time understanding what that person's wishes were, and then where would it be best suited. And I think that endowment moved to Catholic Charities in Gainesville, because they handle adoptions.
Called the doctrine of see, pray.
Yes. So there's a lot of thought. If it's a gift that comes through the foundation for the parish or for ministry, there's a lot of thought given to where that should move to best represent the wishes of that parishioner. So that's in there, and we also have a flyer in here that just touches upon the various different ways that you can do charitable giving through the diocese. So take a look at that. My card is in there. Andy, thank you so much.
Thank you.
And thanks y'all. Have a good afternoon.
I know Andy's not soliciting, but are you still in business, sir, or are you fully retired?
I'm still practicing. One of these days I'll get it right.
We get your permission.